Further hearing in Inveresk plc against Tullis, Papermakers.
Yes, Dean of Faculty.
Good morning, my lords. Might I hope shortly address an issue that was raised by my Lord Roger just before the court rose yesterday, the matter of mutuality and counterpart obligations. And if I can deal with this in short compass, first perhaps by just referring very briefly to the case of Holt against Turpey, which your lordships will find in the authorities at tab 23. That should be in volume 1 of the bundle of authorities, my lords.
Yeah.
It is a decision of Lord Drummond Young, who happens to be the leading counsel for one of the parties in Bank of East Asia.
Losing one.
That is correct, my lord, yes.
You probably learnt something from it, though. Yes.
If we look very briefly at page 308, letters H to I,
Sorry, 308.
H to I,
Yes.
in the headnote, just to see that here the contract was an agreement which involved two distinct sets of contractual obligations: the employment of the defender by the company and payment by the company for his services, and the defender offering his shares for sale and the pursuers paying the price of the shares. And it goes on, the presumption in Globe on contracts that where parties have not recorded their agreement in separate documents, the intention was that the terms of those agreements should be dependent on each other, was either weaker than previously or no longer existed, was the argument, which was rejected, I may say. Now, just going very briefly to paragraph 8 of the Lord Orderly's opinion, he noted, this is at page 312, letter B, the submissions made by counsel on either side raise an important issue relating to the principle of mutuality of contractual obligations, the nature and significance of the requirement that for the principle to operate, the obligations in question must be the counterparts of each other. The existence of such a requirement is clear. Indeed, it is inherent in the very notion of mutuality. The dispute between the parties centres rather on the extent to which the individual obligations on one side of a contract are to be regarded as the counterparts of the individual obligations on the other. In considering that matter, it is, I think, important to have regard to the practical function that the principle of mutuality performs in regulating the rights and obligations of the parties to a contract. Its main practical significance relates to the defence of retention or the right of one party to withhold performance of its obligations because of the other party's material breach of contract. This defence, which is usually referred to as the right of retention, functions as a form of security for the performance of the contract. Its practical importance is very clear. Often it is by far the most useful remedy for ensuring that contractual obligations are properly performed and that the victim of a breach of contract is protected against further loss. It is of particular importance in systems such as Scots law, where the concept of the equitable interest is unknown and quasi-proprietary rights cannot arise merely by virtue of a contract. For these reasons, I am of opinion that the principle of mutuality should not be interpreted in a way that substantially curtails the availability of the defence of retention. That applies in particular to the requirement that the obligations should be counterparts of each other. That requirement should not be used in an artificial manner which breaks up the essential unity of a contract. Now, in my submission, one has to bear in mind that damages are a substitute for performance. In other words, where a party disables himself from performing an obligation in accordance with the terms of the contract, he must substitute his performance with damages. And this is a point actually made by Globe in his work on contract, which your lordships will find at tab 48. And as your lord in the chair, Lord Roger, will be aware, Globe is frequently referred to for his commentary on the matter of contract and retention in this context. And I would simply take the lordships to tab 48 at page 626. 2/3 of the way down that page, your Lordships will see a heading, Retention in Mutual Contracts. And if I can take your Lordships to the second paragraph, beginning where the conditions of a contract, if your Lordships have that.
Yes.
Where the conditions of a contract are that one party should perform some service and the other should pay for it. The obligation of the former is to perform the service in accordance with the conditions of the contract, the obligation of the latter to pay the price or hire agreed upon. If the service is defective, the hirer or employer may have the right to rescind the contract, but such a right is inapplicable or useless in the case where the service in question consists in work on property belonging to the employer. His remedy is then to withhold performance of his obligation to pay in security of his claim for damages for the defective character of the work. His obligation to pay is not extinguished, but postponed, though it may ultimately be extinguished on the principle of compensation, should it be found that the amount due as damages equals or exceeds the amount due under the contract as the price or hire. The right to withhold payment in these circumstances is, in effect, an exception to the rule that an action for a debt admitted to be due and payable is not relevantly met by the defence that the defender has an illiquid or unascertained claim against the pursuer. That rule admits an exception where the illiquid or unascertained claim arises out of the same contract as the debt which is sued for, and where the enforcement of immediate payment would result in enabling the pursuer to obtain satisfaction of his claim under the contract when he has not implemented the obligation of which that claim is the counterpart. Now, I just noticed, my lords, that where a party has disabled himself from performing an obligation, the substitute obligation is to pay damages. And it is that obligation to pay damages which may be regarded as the counterpart of the obligation to pay the price of the services or for the goods.
So that's where the contract is fully executed, apart from payment of the price on the one side and payment for damages on the other?
Indeed, sir.
Can you deal with the point which Lord Glennie makes, that these, I think he accepts, first of all, that the two contracts fall to be read together. He's quite satisfied that this is a single transaction, subject of two agreements. But his point, as I understood it, was that this is something that proceeds in stages. You have the sale on, I think, the 9th of June, and his approach, I think, is to say, well, that part of the transaction earned the consideration, including the additional consideration, he suggests. You then have the service agreement, which covers a relatively short period thereafter, has a specific termination date in November 2005. It's only after that is over that you get to the point at which you can begin to calculate the tonnage for the purposes of the additional consideration. And he separates it out into these different phases and says, well, you can't actually achieve the mutuality you need to, because the breaches you found on in the service agreement are not related to the timing of the additional consideration. Now, that's a summary, but I think that's his basic point.
Indeed,
and I don't think you've addressed that.
And that's really what I want to address, because it arises in the context of my Lord Rogers' question as well. And my point would be that to try and break up this sort of transaction into those sorts of stages is a wholly artificial exercise, such as that deprecated by Lord Drummond-Young in Holt against Turpey. One can see it occasionally in the context of construction contracts, where one can see explicit stage provisions, but one rarely sees it applied elsewhere. But the matter is one that I wish to directly address, and if I may address it in this way, if I ask your lordships, first of all, to go to the Statement of Facts and Issues at page 1, that should be in tab B of the first volume of the core documents.
Yes.
And I just ask the lordships to notice that this is a contract which involved obligations of acquisition and maintenance.
Acquisition and maintenance.
Maintenance. Just to put that in context, my lord, as the joint statement of facts and issues provides in paragraph 2, the dispute between the parties arises out of a corporate transaction. The purpose of the transaction was acquisition by the appellants, that is, acquisition by Tullis Russell of the Gemini brand of paper, customer information, and the related assets from Inveresk, and maintenance of the value of the brand by effective transfer of customer connections. And the two are all part of the one transaction. And Inveresk were not just obliged to transfer assets to Tullis Russell. As we see in recital C of the services agreement, they were obliged to perform certain further obligations, and it is useful just to see how that's expressed. It's in the core volume 2 at page 302 in tab 12. And they were not just obliged to transfer assets to Tullis Russell. In terms of recital C at page 302, they were obliged to perform certain further obligations to enable Tullis Russell to obtain the full benefit and value of these intangible assets.
No, that obligation commences on the effective date, I take it. That's the June date in 2005,
Yep.
and continues to page 309, clause 9, commences on the date hereof and shall continue until 8th November 2005.
Well, in fact, it extends beyond that because, for example, if my Lord goes on to page 313, clause 16.2d, knowing that the completion date is November, it provides that Inveresk are not to do anything at any time after the completion date,
So that's the goodwill clause.
which will damage the goodwill.
Right, yeah.
So it is not so limited, my Lord. And one finds a very similar clause for the period prior to the service period at clause 15.4 of the acquisition agreement, which is at page 278.
The whole of clause 16 is post-completion.
Yes, my Lord. Yes, exactly. But the additional consideration does not fall due until the earn-out period has expired.
Yes.
And by that time, it is alleged by Tullis Russell that Inveresk are in material breach of their obligations to maintain the value of the customer connection and not damage the goodwill of the brands which have been acquired.
Yeah.
And that arises not only in respect of goods manufactured during the services agreement period, but prior to thereto. It also applies in respect to their conduct after the expiry of the service agreement period.
Sorry, I'm interrupting. I just wondered whether clause 15 of the acquisition agreement is part of the answer to Lord Glennie, because his analysis seems to depend entirely on what he finds in the service agreement. He doesn't mention, as I saw it, the fact that part of your pleading relies on clause 15 in the acquisition agreement. And as I understand your position, they really are all part of a parcel, which is to be found partly in one and partly in the other, but they're all related to the same basic point.
Indeed, sir. The maintenance of the goodwill, the maintenance of the value of the assets.
Yes.
And there is a continuum. Whenever Inveresk manufactured product, in respect of complaints regarding that product, they had obligations under 15.4 of the acquisition agreement.
Yes.
I may say that there is a suggestion in the respondent's statement of case that within the pleadings we don't address failures to perform obligations under 15.4. We do, and if that point is taken up, I will take the court back to the relevant cross-references, but I wouldn't propose to do so at the present time. The point really that I'm seeking to make is reflected in Loeb's observation in the passage I referred to. The right of retention involves Tullis Russell being entitled to withhold performance of its obligation to pay in security for its claim for damages for Inveresk's defective performance.
In broad terms, all you're saying, as I understand it, Dean, just as you are being called upon to pay for assets which the value of which they damaged by failure to perform their obligations under the service agreement.
Indeed,
is that in very broad terms?
It can be put as shortly as that, my Lord, and I submit, to employ the words of Lord Drummond Young, that result reflects the essential unity of the transaction. Tullis Russell did not want the trademarks without the goodwill and customer connection that went with them. We are dealing with intangible assets. The transfer of those intangible assets was always going to be fraught with some difficulty. It was essential that steps be taken to maintain the value of those intangible assets during the process of transfer. And that is where Inveresk, we say, materially failed. So what we ended up with before the additional consideration became payable were assets that were seriously damaged by reason of Inveresk's breaches of contract.
I suppose you would say, I'm just trying to test it, that if they had sued you first for payment,
We would have counterclaimed.
you would have put in a defence and counterclaim.
It so happens we sued them first.
Yes.
The inner house are wrong about that. We sued them first, and they raised a separate cross action. So be it. That may have been their perception of the position.
So the order of events is your action was raised first.
Indeed.
Yeah. Yeah. Have you any further points to make on the plea in law at page 186? There was some discussion as to
Well, Lord,
that it's a slightly
it may
unusual
not be
plea.
distinguished by its elegance. That I accept. But subject to the amendment that I proposed yesterday, I would still move the plea in law in that form.
While we're looking at the pleadings, can we go back to the first part of the argument and just see how the pleadings work? Because your argument, I think, ended up with us being an invitation to us to sustain the first plea in law and dismiss the action. Is that right?
That is one route, my lord, as an alternative to the fifth.
And the way that works is, I think, that if we look at the way the
If the Lord allows me just a moment to bring up the relevant...
Yes, it's tab 8.
I have it, my lord, sorry.
And just to work through it, we've got a conclusion at page 162, which is the sum sued for, and a narrative which takes us through the agreements, and at pages 168, 169, on to 172 sets out the relevant clauses in the schedule, which deal with the calculation of the additional consideration. Then there's a narrative in Article 6 of the condescendence at page 172, 173, which ends with the averment at the bottom of 173 that after the inability to agree, on the 14th of March, the pursuers notified the defenders they no longer wish to insist on their proposed adjustments. Now, you refer in your answer to the letter of the 30th of January, which is the notification asking for a tonnage audit. That's referred to for its terms at page 16, but I don't think it's disputed the letter was sent, and that one reads, indeed, there was a notification made. And it's on the basis of your averments, of those averments, rather, you say that they can't escape from the result which that letter produced.
That is my submission.
And if that's right, then on their averments, you say they can't obtain the sum sued for, at least until the tonnage audit is completed.
Well, on the basis of their current averments, given that they haven't pled an alternative case, it would fall to be dismissed. I was considering this last night, and if in fact Inveresk had wanted to plead in the alternative that an expert determination would be required, they could have pled that as an alternative case and then moved to assist the action if the court was against them on their primary case. But they haven't sought to do that. Yet. I quite accept that. I don't want to appear over-formal about this.
They could do that today, couldn't they?
Indeed so, they may do it any time.
Yes. Well, we'll have to see what Mr. Curry says, but I've understood correctly, have I, the way in which the relevancy argument would work.
And that's how it emerges. And while we're at page 173, my lord will notice that the pursuer's own averments, Inveresk's own averments between C and D, are that the pursuers and the defenders agreed to extend the period in which the defenders might respond to this until 30th January 2007.
Yes.
And that was to respond to the adjustments, which would otherwise have been provided for within 5 business days of the relevant period. And having made inquiries, there was further correspondence between the agents which wasn't lodged because that wasn't regarded as an issue between the parties before this court.
Now, there was some discussion yesterday about the significance of paragraph 5.3, I think it is, in the in the schedule about the way costs are dealt with or expenses are dealt with in the event of a tonnage audit proceeding. And one of the points that was raised was whether anything had actually happened after the notification was made. I couldn't find any averments about that. Is there anything that I've missed in the pleadings that tell us how far matters proceeded beyond the notification?
I don't believe so, my lord. My understanding is that, as my lord will see from part 3 of the schedule, it is for Tullis Russell then to instruct the tonnage audit. It's not for Inveresk to do so.
That's right. And indeed, as I understand the way it's worked, it's for Tullis Russell to procure, one, that the audit is carried out, and B, that the tonnage audit statement is delivered.
Indeed.
I think all within the 14-day period referred to. And
they instructed that the tonnage audit be carried out. And there was then an issue because I'm advised Price Waterhouse came back knowing that there were issues between the parties and wrote jointly to both Tullis Russell solicitors and to Inveresk solicitors on 20th February 2007, in which they referred to the fact that they had previously already, on 9th February, provided draft terms of reference,
right,
which hadn't been returned by the parties.
Where do you find that? Is that a...
It's at page 21, it's tab 9 of the appendix part 2.
No.
I understand it's appendix part 2,
Yes.
tab 9.
Yes.
And it's the letter of 20th February 2007 from Price Waterhouse to both Dundas and Wilson and Adelshaw Goddard, who were then the agents acting for Inveresk.
Do we have the letter of instruction?
The Lord allows me just one moment. I believe, my lord, we may have it at tab 6 of the same bundle. Although when I look at that, it refers back to a letter from Tullis Russell dated 5th February.
Yes.
And I believe then that one may have to go back, therefore, to tab 1 in the bundle, which is the letter to Price Waterhouse from Tullis Russell of 5th February, in which they say, please accept this letter as a formal letter of instruction to carry out a tonnage audit as defined within part 3 of the schedule of the to the acquisition agreement.
So that's your implementation of the clause.
Mm-hmm.
Who would be responsible for their fees up to and including 20th of February?
It's not a matter that I have addressed, my lord. If my lord would allow me a moment just to refer back to the relevant provision within the contract, which is at part 3.
Well, that says they determine it, and failing that, it's to be shared between the parties, I think.
Well, in my respect, it would appear from clause 5.3 that all expenses incurred by Price Waterhouse from the time of instruction on 5th February 2007 would be borne and paid equally between the parties. So, for example, if one takes the correspondence from Price Waterhouse back and the fees incurred in relation to that, that would fall within 5.3.
This would be from the moment of acceptance of instructions, presumably. And when do we have any evidence of acceptance of the instructions, or is the true position that they were never accepted?
Well, the instruction was given, my lord.
Yes, but you can... it's like a repudiation. An unaccepted repudiation is a thing written in water.
But could the accountants have directed, for example, that one or the other parties pay their fees to date?
Under a contract between them and somebody else.
If for some reason it was argued that the appointment had failed, then perhaps they would look to the party who had instructed them in the first place. But under the terms of the agreement, all expense flowing after 5th February is to be shared equally between the parties in terms of clause 5(3).
As they direct, or failing such direction.
Subject to their direction, yes.
But that assumes that they have any right to fees before that. There's any relations to fees to which they're entitled. And that must depend upon the contractual position as between them and whoever they made the contract with.
Well,
so when did they make a contract, and with whom, and on what terms?
Well, there was a request. If we look at the letter of the 20th of February in tab 9,
It's tab 9, my
and
Lord, at page
paragraph
21.
3 is the instruction, which is in accordance with clause 5.1. This is the purchaser actually doing what its purchaser is supposed to do, which is procuring.
Yes, indeed, my Lord. They accepted the instruction, and
where
what
do we
they
see
then required was that the parties agree terms of reference for the tonnage audit.
And where do they accept the instruction?
Well, it's implicit in paragraph number 3 of the letter of 20th February 2007, my Lord. Because otherwise they wouldn't have sent them the relevant terms of reference.
And they respond for 4 days later by sending out the draft terms of reference, just to be quite clear what they were supposed to do. So presumably some time and effort was expended in putting those together.
Indeed.
With a view to taking the audit forward.
Well, they would have to formulate the terms of reference that they required in order to complete the relevant audit in terms of Part 3 of the schedule, my Lord.
I just wonder why they need terms of reference at all.
Well, that was a choice on the part of the accountants, my Lord. And it may be a case of safety first from the point of view of the accountants.
Yes, but if their position is that we will, when the terms of reference are agreed, then we will decide whether or not to accept the terms of reference, then the position may be that there was no contractual relationship between them and anybody until the terms of reference were agreed and accepted by Pricewaterhouse. And the significance of all this, as I'm sure is clear to everyone, is that if there is a right to waive, there may come a moment at which the right to waiver no longer exists. But it may be said on the other side that that moment hadn't yet come, at any rate until there was an agreement between Pricewaterhouse and the purchaser.
Well, in my respect...
I mean, I don't know, but I mean, these are all interesting questions.
Do we have the proposed terms of reference anywhere?
If the Lord allows me a moment.
I think all the purchaser did, going back to paragraph 3, was doing what the purchaser was told to do by the contract between the vendor and the purchaser, which was to request that a tonnage audit be carried out. I mean, this wasn't as I understand it, I may be wrong, but it wasn't the kind of thing where it was necessary, if it was an arbitration, for example, to actually agree the terms of a reference.
Not at all. We had triggered the tonnage audit in the form of the expert determination by virtue of the letter of 5th February. The accountants then chose to say that they wanted terms of reference signed off by both parties, they being conscious that there was an issue between the parties.
Before they would accept the request to carry out instructions.
On the
or at least that may be the position.
Well, my response to that would be to look at the second page of the letter of 20th February, first of all, page 22.
They say they can't carry it out. You would say that's quite wrong because they forgot the information and it's all we're asking for is an audit to be carried out.
Their concern
They would say we're not obliged to do anything until we've agreed to it.
Their concern is not the appointment. Their concern is their ability to conduct the appointment they have received in the absence of what they say is cooperation from the two parties. That's reflected in paragraph number 6. And in paragraph number 7, they say, in conclusion, as things stand today, we have not yet been provided with an agreed terms of reference by your respective clients, which we consider necessary for the purpose of conducting the tonnage audit. So the concern was not the appointment, their concern was with the manner in which they were supposed to conduct the tonnage audit.
On page 2 of this bundle, there's a letter which starts off under the terms of reference, section 6. What are they talking about there? A letter to Pricewaterhouse.
That may be a reference to clause 6 of part 3 of the schedule. It bears to be a letter from the finance director of Tullis. It also bears to be an undated letter and indeed a draft in the copy I have here, my lord.
Well, you may be right, but that letter dated February 2007, it says, under the terms of reference section 6, we were asked to set out our position with regard to matters in dispute. So there appear to be some form floating around of terms of reference.
Well,
So-
I'm not aware of that, my lord, I must say. And it doesn't seem to be reflected in the terms of the letter which Price Waterhouse sent out on the 20th of February.
Was this the first time Price Waterhouse came into all this, or were they the accountants of the purchasers
They were the purchasers
before?
accountants.
So had they prepared all the documents in the first place, had they? Or
Well,
not?
they would have presumably...
Or had they played a part, rather? in the-
They would have been responsible for their audit responsibilities, but I don't think there's any suggestion that they prepared any documents pertaining.
Well, I think I found the answer. If you go to page 21 and look at paragraph 4. We provided the purchaser with our draft terms of reference, also addressed to the vendor. You got them on or before the 12th of February. So it looks as though PricewaterhouseCoopers put up a proposed terms of reference, but we don't have them. Is that right?
We don't have them, but it would appear that Inveresk lawyers were not happy with them, and in the absence of those, it would appear that Price Waterhouse was saying we cannot conduct the tonnage audit.
Yeah, to follow that. But I don't know whether your clients were happy with them either.
Well, I'm not sure that it would actually make any material difference with respect, my lord, if they weren't actually agreed or indeed relevant and necessary to the process that had to be carried on.
Well, that goes back really to my first question, is why they needed them at all.
That's highly questionable, my lord.
Well, there's a letter of page 14. There's a letter, I think, from your instructing solicitor, Dundas and Wilson. Is that right? In which they say in the final paragraph, as the agreement specifically provides that Tullis Russell shall procure that you carry out the audit, it's not necessary for your appointment be jointly instructed, nor for your terms of reference to be jointly accepted, which I would understand to be your position.
Yes.
Now, they didn't seem to understand or accept that, but you would have maintained that, I suppose, if matters had gone on. And they were chosen, I think this is clear enough from 5.1 in the schedule, because they were your accountants already. I mean, that was...
Under 5.1, they were the party that had to be instructed for that purpose.
Yeah. Well, I'm not sure we can take this point any further.
Can we go any further than the pleading?
In the pleadings themselves, my lord, with regard to the appointment,
Yeah. Very much about page 18,
21C to D, my lord.
21.
Answer 7.
To 21, C to D.
Yes. But also your answer at page 18. You read that to us.
18A to B.
Yes. And
The
B,
defendants
C.
complied with the pursuer's request and instructed their accountants to carry out the tonnage audit in terms of the asset purchase agreement by a letter dated 5th February 2007, which is produced.
Then you say
The pursuers refused to agree to the expert's terms of engagement unless, amongst other things, the defenders agreed that the only issue for the expert to consider would be the adjustments to the draft consideration accounts proposed by the pursuers.
You say there was a difference of view as to what the audit was all about, and you say it was to actually verify the figures for tonnage.
Indeed. This really goes back to the approach that Inveresk took before Lord Glennie in arguing that he was really looking at an adjudication in which the accountant appointed was simply to determine whether it was the original figure or the adjusted figure. And that theme runs through Inveresk's position, and it would appear to be that which led to the appointment effectively not being reflected in the terms of reference that Price Waterhouse has sought. But we certainly aver and offer to prove at 18A to B that we complied with Inveresk's request and instructed the accountants to carry out the tonnage audit. And as I say, at 21C to D, we go on to explain that now that the expert determination process has been engaged, both by the Inveresk's own request and by the operation of the contractually agreed time period, parties' own views on the correct tonnage figure are not determinants of the issue. The expert is to confirm and verify the tonnage.
Just going back, I beg your pardon.
No.
Just going back to page 14, it looks as though your clients were happy with the terms of reference, whether or not they were required. Because it ends up by saying, in the absence of any cooperation, we feel it's appropriate that the terms of reference be issued to Tullis Russell and the tonnage audit be computed in accordance with the agreement. So it doesn't look as though you were complaining about the terms of reference.
Well, indeed, that is what is reflected at page 18 of the report.
Could we see the terms of reference?
I don't know if they're lodged.
Because these terms of reference were drawn up at a time when this dispute hadn't become live, weren't they?
Inquiries may be
Because
made.
they didn't take the point until they took the point on the 14th of March, didn't they, the other side?
I think what happened, but do correct me if I'm wrong, it was they, the accountants, who prepared a draft terms of reference.
Yes, it wasn't Inveresk, my Lord.
This is the second paragraph on page 13. So that they seem to think that they needed terms of reference to proceed. The opposition was they didn't actually need that. You were content, I think, to go along with the idea if that's what they thought they wanted.
We told them.
I mean, the irony of all this is that at the moment of this correspondence we're looking at, the only issue between the parties was was the issue between the 900,000 and the 1 point whatever it was million. That was the only issue. The real issue only arose after the 14th of March.
No, that's not correct, my Lord. Already by the end of January, Tullis Russell's lawyers had pointed out to Inveresk that an error had apparently been made in the calculation.
Is that in the facts and issues? I hadn't appreciated that.
Well, that's in the enclosure to the letter of 5th of February as well, in tab 1.
It's in the statement, referring to my Lord Clerk, at paragraph 2, letter H, Roman numeral 6, which is at page 4 of the statement of facts and issues.
So H, little 2?
Little 4, my Lord.
Oh, I see, yes, I see.
On 30th
I beg your
January,
pardon, yes, I see.
Tullis Russell intimated to Inveresk that they were unable to agree to Tullis's proposed adjustments. They also advised that, in their view, the draft consideration accounts incorrectly included tonnage that related to non-branded paper.
Sorry, I've missed which paragraph we're looking at. It's
It is
H.
Roman numeral 6, my Lord,
H6, yes,
towards the
thank
foot
you.
of page 4 of the statement of facts
Yes.
and issues.
Yes, thank you, I'd overlooked that.
Yes.
So by this stage, both parties were conscious of that issue. On 5th February, Tullis Russell did what they were able to do under Part 3 of the schedule and instructed the accountants to make an expert determination.
Are there any averments about what the accountants did? None, I think.
Beyond the averments at 18 and 21, I don't believe there are, my Lord, because as far as Tullis Russell were concerned, they had been instructed.
Yes, I mean,
And that was reiterated
that
by...
tells about what the parties' positions were, but it doesn't. There's nothing about the accountants, what they did.
All we know is that they came back with a set of terms of engagement, which they were told by the agents for Tullis Russell were not required, but which they appear to have wished to insist upon, given that they were conscious that there was a dispute between the parties. Those terms of engagement, as we have 18A2C, were not acceptable to Inveresk because they wanted terms of reference that determined that the only issue for the expert to consider would be the adjustments which they had proposed. That was not acceptable to Tullis Russell.
Your position at page 21, just about letter D, I think is that the determination process was engaged
That is the term averment.
by the
yes.
actings between the parties, but you're not actually going on to say what the accountants did thereafter. I don't think you're not founding on that aspect.
Well, at the end of the day, my lord, it will be a question of mixed fact and law as to what the position of the expert was as at the relevant date. But one can see that he responded to the appointment by proposing draft terms of reference to the parties, and one has that reflected in the letter of 20th February.
But, I mean, you do not have any averments, and nothing that I read says that their right, to, if they have one, to waive is barred by some acting on the part of the accountants.
Well, with respect, my lord, that would be tantamount to pleading not an issue of fact, but an issue of law. And it respectfully appears to me that what we have here is a situation in which at one time, albeit not in the inner house, an argument of waiver was advanced, but not on that ground, my lord.
I fully understand you've got a case about it was blocked by what you did and you engaged the process and so on, but you haven't averred any facts about what the accountants did. Therefore, insofar as you were seeking to make a case that they couldn't, they were prevented from waiving because of something the accountants did, it doesn't seem to me, with respect, that there is any factual basis there at all.
Well, in my respectful submission, I would take issue with that and refer again to the pleadings at 18A to B. If we had instructed the accountants to carry out the tonnage audit.
Well, you don't have to argue an actual waiver. The fact that one gets into all sorts of difficulties once the matter is put in the hands of the accountants may inform interpretation and show that it's difficult or impossible or wrong to construe this clause as allowing a withdrawal.
Well, I rather share Lord Roger's position that if this case was to go to proof, and you're entitled to lead evidence which are the subject of averment, you'd be in difficulty in trying to lead evidence about what the accountants did, because you've got nothing in the pleadings to allow you to do that.
Well, my lord, if I require to amend at this stage in order to aver that the accountants responded in the terms they did in the correspondence produced, as reflected in the statement of facts and issues, I will do so. But in my respectful submission, the key point here is that the accountants were appointed in terms of Part 3 of the schedule, as is averred at 18A to B. Now, where they went after that, in my submission, is really neither here nor there. Whether they misconstrued their appointment, whether for their own reasons they wanted to have a signed-off joint terms of reference, whatever is neither here nor there in my submission. They were appointed, as we aver, at 18A to B in accordance with Part 3 of the schedule.
Well, we'll obviously have to consider whether that's right or wrong.
And in the meantime, perhaps I can consider my draft minutes of amendment.
Well, I think maybe...
Could I ask you one last question?
Yes, of course, yes.
Just going back to the letter of your paragraph 6 reference in little 6.
I'm sorry, paragraph...
little 6.
in the Part 3 of the schedule.
In the facts and issues, where you pointed out that on the 30th of January, the point was taken about the accounts incorrectly including tonnage that related to non-branded paper. Now, is that a reference to the letter on page 337?
337.
337.
That is tab 16 that the Lord is referring to.
Yeah, sorry, tab 16 of the main appendix.
It would appear to be so, my lord.
And where do they say that?
Definition of tonnage.
On the first page, my lord, halfway down, in addition, Tullis Russell has ascertained that the tonnage figures used to calculate the draft consideration accounts incorrectly included tonnage that related to non-branded paper.
Yes, I see. And then The next letter after that appears to be page 341. Is that right?
And that is where Inveresk demand a tonnage audit.
But when they say we refer to your letter dated 30th January received by email at 1840, that's a reference back to page 337, is it?
I would assume that it is, my lord, unless there's anything to suggest the contrary.
And so it was after that that they exercised their right.
They acknowledged the letter dated 30th January in the opening to their letter of 31st January. My lord is correct. And then at page 2 of that letter, 31st January, they say we hereby notify Tullis Russell on Inveresk's behalf that it requires a tonnage audit to be undertaken.
Yes.
Thank you.
Yes.
That is correct, my lord.
Yes.
I wonder if my lord would allow me just one moment. Lord, it is confirmed that the letter of 30th January is at 337, is the letter that is being referred to
In little 6.
at page 341.
Yes. Thank you very much indeed, Dean.
My lord, I'm obliged. If there's nothing further that I can add, then I would rest my submissions there.
Ms. Deliberovich-Broom, do you wish to add anything?
Nothing to add, my lord.
Thank you. Mr. Curry.
Lords, I'll start, if I may, with the issue of the additional consideration. And as it happens, I've proposed anyway to start by touching upon the issue that's just been under discussion. And if I may refer, my lords, to part 3 of the acquisition agreement, schedule part 3, which you also find at page 292.
Yes.
And to go to paragraph 5, in light of the discussion that's just taken place, it's important in my submission to bear in mind what Tullis Russell's obligation was under paragraph 5.1, and that wasn't to instruct, it was within 14 business days from the date that the vendor notifies the purchaser that requires a tonnage audit. The purchaser shall procure that the purchaser's accountants carry out the tonnage audit to confirm and verify the tonnage and deliver to the vendor the tonnage audit statement. That's the obligation.
Yes.
And a tonnage audit has never been procured and delivered by Tullis Russell in accordance with the obligation on them under paragraph 5.1. The reasons for that, stated neutrally, because if my lords cared to read through the correspondence in part 2 of the appendix, you'll see that there's a considerable amount of correspondence about this, but the reasons for that were, first of all, a dispute over PwC's terms of engagement, in particular a dispute about a provision excluding PwC's liability, which is referred to as a hold harmless obligation. And there was also a dispute between the parties about what material should go before PwC. And my lords can see from the draft letter attached to tab 1 of the part 2 of the appendix that what Tullis Russell were about was trying to get the accountants to look not at the draft consideration accounts that had been submitted in accordance with the contract, but at what they described in the last paragraph as the revised tonnage figure, which was the one that they produced after they came to the view that they had the draft consideration accounts within the contract were based upon an error.
But that's subject to your audit, of course.
Yes.
That qualification.
Yes. But all I'm saying is that I'm not asking the court, nor indeed has either party put in issue in the pleadings the rights and wrongs of this. What I'm saying is that the reasons, stated as neutrally as one can, for a tonnage audit never having been procured and served is that there were these two main areas of disagreement, and Tullis Russell simply did not get on and do what they were obliged to do under paragraph 5 of part 3, which was procure and deliver a tonnage audit.
The delivery had to be within the 14 days, did it? The delivery of the audit.
Procuring and the delivering had
So
to
the the contract contemplated that the whole operation would be done within 14 days, did it?
Well, if we go to paragraph 5.1, it says, within 14 business days from date the vendor notifies the purchaser that requires a tonnage audit, that the purchaser shall procure the purchase accountants carry out the tonnage audit, confirm, verify the tonnage, and deliver to the vendor the tonnage audit statement. So that both have got to be done within that 14-day period.
I think that's what PricewaterhouseCoopers understood, actually, because at page 22 they're complaining that they've actually already reached the 14th day and still haven't got agreement as to what to do.
The point I'm making, Lords, is that Tullis Russell did not comply within the 14 days and have never procured and delivered a tonnage audit. The second matter...
What difference does that make in the context of this case?
Well, I'll come on to deal with that, my Lord, if I may. But at the moment, I'm simply trying to deal with some of the factual assertions made by my learned friend. And the second matter I'd like to pick up is that the Inveresk strongly reject any suggestion that it took advantage of what it knew to be an error in the draft consideration accounts. The draft consideration accounts were broadly consistent with monthly figures supplied by Tullis Russell during the earn-out period. And Inveresk's position in relation to the products to be included in the tonnage audit is summarised by Lord Drummond Young at page 154, in his opinion, at page 154 of the appendix.
I'm so sorry, what page again?
Page 154, my Lord.
Thank you.
And he's dealing with the second conclusion, which is a declarator that quantities of papers under the dual code Duo, Libra and Duocard grades, which orders received by the defenders in the period, are included in the tonnage for the purpose of calculating the additional consideration, and so on. And Lord Drummond Young said, the issue raised in this conclusion is only relevant if a tonnage audit proceeds. It's explained in the pursuer's pleadings as follows. The defenders have claimed that in the course of the tonnage audit, they're entitled to review the figures included by them in their draft consideration accounts to exclude sales of papers under the dual code Duo, Libra and Duocard grades. The pursuers dispute not only that the defenders have any entitlement to review the draft consideration accounts prepared by them, but also the proposition that these grades of paper should be excluded from the tonnage, and so on. And at page 157, Lord Drummond Young concludes, in my opinion, the pursuers would, if there had been a live reference to tonnage audit, have been entitled to declare it in terms of the second conclusion. The declarator does not alter the matter referred to the defendant's accountants, which remains precisely as specified in paragraph 1. What the declarator does is to resolve a dispute that has arisen between the parties as to what is included in the definition of product for the purpose of determining the tonnage, and so on.
I don't think I quite understand what Lord Drummond Young is saying.
Well, what he's saying, Lords, is that if there had been a live reference to tonnage audit, the pursuers would have been entitled to a declarator that the definition of tonnage within the agreement included certain products. And all I'm seeking to do at the moment, Lords,
I'm just trying to understand.
Yes.
Sorry.
all I'm seeking to do at the moment is to say that the Inveresk's position is that the draft consideration accounts originally provided in December 2006 proceeded upon the right basis.
So on the basis which is set out at page 163,
Yes.
we can see the terms of the declarator there.
Yes. Because
Which is also consistent with the fact that when they got the letter the 30th of January, they then said, we'll have a tonnage audit.
Exactly. And I'm simply dealing with the assertion or insinuation which has been made from time to time in this case, that what this is about is Inveresk taking advantage for what they knew to be a mistake in the December draft consideration accounts. And that the Inveresk position is that's simply not the case. And as Lord Roger has pointed out, on page 333 at tab 15, which was on the 10th, it is recorded that...
Sorry, page...
It's page 333, my lords.
This is... Sorry, I've lost which volume we're
It's
in.
the letter of the wrongly dated the 11th of December from Inveresk solicitors. I'm sorry, it's page 333 in the
Appendix
part one of
volume
the
2,
appendix.
Yes.
It's the big volume.
Yes, I've got
Yeah.
it. Thank you.
Do we know why it's wrongly dated?
We don't actually.
I mean, it looks as if it's only the first page that's wrongly dated,
Yes.
and the second and third pages are correctly dated.
Yes.
And in the first paragraph, it says, as you will be aware,
Probably used the wrong template.
representatives of Inveresk, together with their accountants, KPMG, attended at the Tullis Russell's premises at Markinch on Wednesday 10th and Thursday 11th January 2007. And then if we turn on to page 337, which has been looked at, and I'll try and deal with it very briefly, which is Tullis Russell's solicitor's letter of the 30th of January. In the last paragraph before the heading definition of tonnage,
Yes.
it said, in addition, Tullis Russell has ascertained that the tonnage figures used to calculate the draft consideration accounts incorrectly included tonnage that related to non-branded paper and so on.
Yeah.
As Lord Roger has noticed, if we go to the next document, tab 17, which is on page 341, having received that letter, Inveresk solicitors notified that they wanted a tonnage audit. We can see that in the bottom paragraph on the first page.
Yes.
And it wasn't until the 14th of March 2007, page 349, that Inveresk's solicitors notified Tullis Russell that no adjustment need be made to the draft consideration accounts and that Inveresk withdraws its request that a tonnage audit be undertaken. So, some 6 weeks after Inveresk notified that it wanted a tonnage audit, no tonnage audit had yet been procured or delivered. And I will come on to deal with the implications of that for my argument in due course, but I just wanted to establish the facts.
So, is it too simple to say that the real issue was not so much being sure that the figures were accurately recorded as the period went on, but what the figures were that should have been included in the overall tonnage figure? And the dispute was as to whether Tullis Russell were right in saying a certain brands of paper shouldn't have been in there at all, and you say they should have been, and if that dispute had gone on, you would pursue that by getting a declarator establishing your position. Is that right?
Well, all I'm really seeking to do, my lord, at this stage is to refute the suggestion that the letter of the 14th of March was simply taking advantage of an error which Inveresk believed Tullis Russell had made in the draft consideration accounts.
Yes. You're saying there was a genuine dispute about
Yes.
what should be included.
Yes.
As of the 30th of January, both parties thought the consideration accounts were wrong, didn't they? You thought they didn't give enough, and the other side thought they'd given too much.
Without conceding anybody's entitlement to take positions of that sort, so far as Tullis Russell are concerned, that would appear to be the position factually, yes.
Mr. Kerry, you may come back to, just so as if we get back to page 157, Lord Drummond Young, just so as I understand what the position is and why he says that, what he does. He says that you would have been entitled to the declarator. And then he says what the declarator does is to resolve a dispute and so on. He says that declarator does not alter the matter referred to the defender's accountants, which remains precisely as specified in paragraph 5.1. What does he mean by that?
Well, I think he means that it's simply for the accountants to get on with the tonnage audit.
How do you do that if you don't know what the product is that you've got to count up?
Also, why isn't that a matter for the expert?
Well, I think it would be up to the expert in the first instance to just to do that.
Yeah.
And then there would be issues after he'd issued his determination as to whether he could be reviewed on a point of law.
So is this why PricewaterhouseCoopers are rather keen to know what their terms of reference were?
I don't think so, Lord. I think the terms of reference are a rather different issue from the dispute about what material should go before Tullis Russell. I think the terms of reference were the contractual basis upon which PricewaterhouseCoopers were prepared to do the work, and they include. If we look at page 14 in the appendix part 2, it gives us a flavour of what was included in the terms of reference. So this is Dundas and Wilson's letter to Pricewaterhouse dated the 16th of February.
Page number?
Page 14, my lord. The letter starts on page 13.
Yes.
And on page 14, Dundas and Wilson say, would be obliged if your terms and conditions of business could be amended so that Scots law is the governing law and the Scots courts have exclusive jurisdiction. Having regard to Inverest's stated position regarding the determination of the tonnage in its second letter of 8th February 2007, we will require amendment to the indemnity detailed in clause 18 of the draft terms of reference. So I think, I haven't seen the terms of reference, I'm not sure that anybody in this room has, ironically, but I think they were, at least to some extent, dealing with the conditions that PwC were seeking to impose upon the work that they were carrying out.
They were making a meal of it.
I'm sorry, my
They
lord?
were making a meal of it.
Yes,
Yeah,
I mean,
right, yeah.
and no doubt had an English jurisdiction clause saying if you sue us for getting this wrong, you'll have to do it in England. And I believe from reading through the correspondence that some of the controversy was about an attempt by PwC as experts to exclude or limit their liability for
Indemnity.
Yes. Yeah. So I think that's what the issue about the terms of reference was. So, my lords, before I move on to as I move on to look at the provisions in the schedule part 3, I would invite my lords to view the matter in the context of these facts, certainly rather than an insinuation that this was simply Inveresk seeking to take advantage of what it believed to be a mistake, because that, according to my information, is certainly not the case. And of course, this matter has not been the subject of averment at all. But, so what we see is that I think the two things I'd really invite your lordships to take out of this is, first of all, to look carefully at what Tullis Russell's obligation was under paragraph 5.1, and secondly, to note that that obligation was never obtempered, has never been obtempered.
And you place emphasis on the word procure.
Yes, indeed.
So just, I know you said come back to it, but in a sentence, what is your submission as to the effect of that?
Well,
I mean, never mind what happened up till then. What is the effect of a failure to procure the tonnage within the 14 days, do you say?
it sets the context for the situation in which Inveresk found itself by March and was faced with a situation in which no tonnage audit had been procured or delivered by Inveresk, by Tullis Russell.
Could one be more precise? I don't. You say the context is that the context for your client's withdrawal
Yes.
from the request?
Yes.
Because I think Lord Glennie makes the point that there was a very tight timetable. Obviously, it had not been adhered to.
Yes.
Your interest was to obtain a payment as soon as you
Yes.
could. The machinery provided for in Clause 5 had broken down.
Yes.
For reasons we've seen in the correspondence, and you say, well, in that situation, we can simply insist on payment.
Yes.
There's nothing actually in the
No.
schedule to do that, but
No, but I will. I'm not seeking to dodge the question at all, but I will come on to it. But my position is that in that situation, although there isn't express provision for it, the court below has correctly, and your lordship should also ascribe to the parties the intention that when Inveresk no longer insisted in its adjustments or wished to invoke a tonnage audit, they were entitled to withdraw the adjustments and the request and to have the additional consideration fixed in terms of the contract.
is it part of that argument that, from their part, Tullis Russell have no right under the machinery and the schedule to insist on adjustments of their own?
It's not I think the way I'd put it is that the fact that Tullis Russell has no right to insist on adjustments is entirely consistent with my submission that a tonnage audit needs to take place in terms of this contract only where Inveresk maintains a challenge to the draft consideration accounts.
Does that mean you accept that, according to the absolutely literal wording of Part 3, and in particular 4.5, the payment date hasn't actually arrived?
Well, if one looks at 4.5, that refers back to 4.3a and b
Yes.
and c, all of which contain the words the review period.
Yes.
And my submission will be that the inclusion of the words the review period in paragraph 4.3 is not there for the purpose of precluding the vendor Inveresk from notifying that no adjustment needs to be made to the draft consideration accounts, or notifying that it does not wish to let that a tonnage audit be undertaken after the review period. The purpose of the words during the review period are to provide a timetable for the summary procedure which is set out in this contract.
But if you, I'm not saying it should be read absolutely literally,
Yes.
but if it is read literally, the combined effect of 4.5 and 7.2 is that read absolutely literally, the additional consideration isn't due. Now, that doesn't make any commercial sense. So the question is, how should it be read to make commercial sense?
Yes. Well, I think I would have to accept that an absolutely literal reading of 4.3, the right is conferred during the review period. But my submission as I develop it will very, very succinctly, I hope, will be that the words during the review period are not there intended to preclude the vendor Inveresk from doing the things in 4.3a or b at a later stage.
Could one say, Mr. Curry, that there is clearly a very strict timetable which is in your client's
Yes.
interest to
Yes.
obtain payment as soon as possible within the relevant period. But if
Yes.
the timetable slips, you're able to waive insistence upon it, and we can see that to some extent you were prepared to do that up to the 30th of January.
Yes.
But there would come a point at which you can say, well, although the timetable has gone, that in a way strengthens our position that we actually want payment now.
Yes, indeed. Lord, in my submission, the draft consideration accounts prepared and served, prepared and served by Tullis Russell in terms of paragraph 4.1 are the contractual basis initially for further procedure. And the definition of consideration accounts means the accounts prepared in accordance with paragraph 3, and paragraph 3 says the consideration accounts will specify the tonnage and a calculation of the additional consideration. So under 4.1, the purchaser is to prepare and serve on the vendor a draft of the consideration accounts. And as I think has been noticed already, Tullis Russell, the purchaser's position, is protected by the fact that they draft the consideration accounts on the basis of information which they keep. And Inveresk's position is protected by its right to propose adjustments or invoke a tonnage audit, or indeed simply to accept the draft consideration accounts and thereby obtain prompt payment.
So is your position, Mr. Kelly, that even though they're just a draft of the consideration accounts, whatever figure Tullis Russell put in, they can never retreat from that figure. They themselves can never reduce it.
I think the way I would like to put it is this. A tonnage audit was triggered in this case because Inveresk's adjustments were not agreed. That gave Inveresk the right to notify that it required a tonnage audit, which it did. And the whole process is driven by Inveresk challenging the draft consideration accounts.
I hear what you say. I'm still waiting for the answer to the question.
Well, there is no room for any adjustment to the draft consideration accounts. That's part one of the answer. And in terms of the tonnage audit, that is simply for the accountant to procure, for the accountant to prepare.
But supposing that the Tullis Russell had concluded, and there was an error in it, and they'd put an extra zero onto the thing, and it was wrong.
Yes.
Are they stuck?
Yes.
They're absolutely stuck.
Unless a tonnage audit takes place, which produces a different figure.
And that's entirely in your hands.
Yes.
So if you see that it's wrong, that it's wrong to your advantage, you can simply say, well, I'm not going to make any adjustments to these, and we'll take it.
Well, can we look at paragraph 4.2? Sorry, 4.3.
Yes, no, I understand.
Yes.
Okay, of course.
I'm just by way
Seems
of...
very absolute to me,
Well,
and not terribly practical.
There would have to be an implied term of some sort to deal with plain errors.
that may be so, but if we look at paragraph 4.3, if the vendor notifies the purchaser during the review period that no adjustment needs to be made to the draft consideration accounts and so on, then the draft consideration accounts become the consideration accounts. And the Tullis Russell are not relying on this case on any implied term which allows them to adjust the draft consideration accounts.
You say there couldn't be one, no?
Well,
Even in this case of an extreme error.
maybe there could, my lord, but that's not the issue in this.
Fraud and, the other, whichever it said in the tonnage audit thing, fraud and manifest error, which is what's in the qualification in 5.2.
Well, that may be the case, Lord, may be. But what we're concerned with is what happens if a tonnage audit is not procured and delivered within 14 days, and the vendor then wishes to withdraw its adjustments. That's a very different question from what the legal rights of Tullis Russell might be had they, during the review period, for example, sought to withdraw the draft consideration accounts on the basis that there was fraud or manifest error.
Supposing there was an error about product, because if you look at the definition of tonnage, it's the amount, this is page 292, tonnage means the amount in tons of the product. So in order to carry out the audit, you have to know what the product is. Now, it appears as there was a dispute as to what the product really was for the purposes of this calculation. Is that right? Because there were items that you say were properly included in the draft accounts, which they, on reconsideration, were saying shouldn't be there.
According to Tullis Russell, in their letter of the 30th of January, they included product which should not have been included. They say that they included products which did not incorporate the trademarks.
Yes. Now, could that fall within the scope of manifest error?
I'm not sure that it does, my lord, with respect. If there is a dispute about it, which, as illustrated by Lord Drummond-Young's analysis, on which there are arguments on both sides, I'm not sure that amounts to manifest error. A manifest error may well be a decimal point in the wrong place.
But are we using manifest error as being the phrase in 5.2?
Well, that was what was put to me,
Yes.
I think, that as an
But
example.
surely that's a manifest error or fraud on the part of the accountants.
Yes,
Yes,
but
no, of course.
yes, I think it's just
taken
been
as an
used
example
by
of the kind of thing that-
Lord Roger or Lord Collins, I don't recall, as an example of the type of matter that might allow the purchaser.
But you'd have to imply a term, wouldn't you,
Yes.
to
Yes,
some such
absolutely.
effect. I
Something
mean,
of that
one might say it's perfectly obvious if there'd been some fraud, that's be no difficulty in unravelling it. If there was some kind of manifest error in the sense that anybody who read page 5 could see that there was a naught in the wrong place, you'd have to imply a term that could be removed in order to make the contract work, at any rate to apply the English test for.
If we confine
implied
ourselves to
term.
the situation which obtains here, which is where, on the face of it, we're not talking about a manifest error, but an issue, my submission is that the position of Tullis Russell, the purchaser, is protected by the fact that it prepares the draft consideration accounts from information kept by it.
It only has 5 days to do it.
I'm sorry, my
It
lord?
has 5 days to do it.
Well, but as a matter of fact,
They know a bit beforehand.
Yes.
yes, as a matter of fact, Tullis had been supplying monthly figures to Inveresk throughout the whole period, throughout the whole earn-out period. And it wasn't a question of having to do it all in 5 days. 5 days would no doubt be to finalise it.
So books and records would be kept, you say, during the period, which should then be brought up to date.
Yes,
Yeah.
yes.
But just as an aside, the Dean of Faculty refers us to Clause 6A, which is another protection. I mean, it's not as if Tullis Russell have all the information up their sleeves. You're able to have a look at this material too, aren't you?
Yes, that is true. But as a matter of fact, I don't know if it's necessary for me to go into it, but there are averments about why it was that Inveresk and KPMG were not allowed access to the Tullis Russell books until the 10th and 11th of January, and that was the reason that the whole process was held up. These I don't know that it's necessary for me to go there, but the averments are set out on page 548. And I'm looking, maybe we could look at them quickly. It's page 548 and 549. These are
This is in the other action, is it?
yes, that's right. This is in the counterclaim, I think. Yeah, it's in the counterclaim in the other action, and it's averred, foot of page 548, explained and averred that the pursuers have complied with all the obligations incumbent upon them in terms of the acquisition agreement. The defenders tried to impose access to books and records rather than ensure access at a reasonable time. In a letter by the pursuers' solicitors dated 20th October 2006, the defenders were advised that access could not be accommodated on 25th October. Nevertheless, and without engaging in further discussion with the pursuers, the defenders attended at the pursuers' premises on 25th October. The defenders proceeded again to attend at the pursuers' premises on 13th November 2006, having been advised on 10th November 2006 not to do so. I think these are averments made by Tullis Russell, and so on. So there was an issue about when Inveresk were to be allowed to have access. I don't think much, if anything, turns on that now, but that is the factual background. And
Is the issue about product, which is relevant to tonnage, is that one which can be seen, can be resolved by simply looking at the orders and the invoices, or is it more complicated than that?
I think it's more complicated than that because there is an issue about what product should be included within the definition of product.
Well, we know it's
trademarks.
product incorporating the trademarks,
Yes.
but you need further evidence, do you, in order to work out whether a particular product, as described in, say, an order or an invoice, is a product incorporating the trademark?
I think the easiest way of dealing with this is to look again at Lord Drummond-Young's opinion at page 154.
Page number? Sorry, I missed that. Page number?
154.
154.
Just about halfway down, I perhaps should have read further on than I did before. Halfway down the paragraph on the second half of page 154, Lord Drummond-Young says, "It is averred that three names, Jewel Coat, Duo, Libra and Duocard, are brand names which certain former customers of the pursuers applied to the pursuers' products for the purpose of onward sale. The product was nevertheless sold by the pursuers as grades of Gemini, and thus fell within the definition of product in the asset purchase. It is further averred that the defenders were made aware of that practice in the course of disclosure of documents in the due diligence exercise." So there's an argument that that Jewel Coat, Duo, Libra and Duocard were in fact sold as grades of Gemini and thus fell within the definition of product in the asset purchase agreement, which is in the schedule part 3, para 1.1, product means products incorporating the trademarks. So what what Inveresk are arguing is that products additional to those which Tullis Russell contend incorporate the trademarks were sold. So I don't know, because I have never seen the documentation, whether the expert would be able to resolve that issue by looking at packaging, invoices, and so on.
Well,
I think what Lord Drummond-Young envisaged in the other passage I read, which is on page 157,
was that they couldn't.
is that if the second conclusion ever became a live issue, he would have pronounced declaratory in terms of the second conclusion of the summons, because the Tullis Russell had no relevant defences. On page 157, he says, "The dispute is formulated clearly in the pursuer's pleadings. They aver that the specified names were brand names used by customers in respect of paper sold by the pursuers as grades of Gemini. The paper thus fell within the definition of product. In the asset purchase agreement, the defenders make a formal denial of the pursuer's averments, but do not provide any explanation of that denial or why they contend that the pursuer's averments are incorrect. The action is at the stage of a debate on pleas or relevancy, not a motion for summary judgment. Consequently, it's to be expected that the parties' pleadings will be in a form sufficient to state a relevant case. In my view, the defences in this aspect of the case are irrelevant. Consequently, if I'd taken the view there was an effective reference to tonnage orbit, I would have pronounced declaratory in terms of the second conclusion of the summons."
So on that basis, and is that the same issue as
Yes.
the one which is taken in the letters we looked at?
I believe so.
And here is Lord Drummond-Young saying that their case is bound to fail.
I mean, to be
So
fair,
would the expert?
to be fair, on the basis of the pleadings that they then
Yeah.
were
Well, I
deployed.
follow that.
Have they been amended since? Yes.
Have they been amended?
Yes, no,
Been amended
I know, I'm
Yeah.
not saying.
No, but I'm only interested in it
Yes.
because it does throw some light upon what it
Yes.
is this expert is going to do.
I'm simply referring to this, not to suggest
No.
that there is no defence, but simply to say that there is an issue,
Yes.
and to give the court some flavour of what the issue is.
Yes. So,
yeah,
sorry, just to be quite clear, what happened, I mean, he expressed that view,
Yes, and
then amendments were made,
Yes.
then it went to Lord Glennie and so on.
Yes.
And the record as we have it now is the amended record, is it?
Well, I think the other complication in the case is that tab 26, and I'll come on to this when I look at clause 15.4 of the asset purchase agreement, but tab 26 are the pleadings that were before the division. And
Tab 26.
yeah, and tab 25 are the current pleadings. I think the only material respect in which they've changed for the purpose of this appeal are the attempt by the...
The 25 is the other action, isn't it?
Yes, 25 is earlier. These are the pleadings that were before the division. These are the... Sorry, perhaps a confusing issue. These are the pleadings in the other action.
Yeah.
That's right, yes.
And these are the pleadings that were before the division. And tab 25 and the other action are pleadings then. And
The current ones, I hope, are the ones which
Just-
are at tab 8.
tab 8, yes.
That's what I thought.
Just so I do understand this point about products. In the services agreement, products is defined to mean products which incorporate the trademarks.
Yes.
Tullis Russell were selling cardboard to customers who wanted trademarks which were not listed trademarks affixed to the product, to the paper. But normally, in the past, you had affixed relevant trademarks to that. Is that the position?
I think if I understand the position correctly, the argument is that the definition in Schedule Part 3 has to be read in light of the surrounding circumstances. And the surrounding circumstances are, according to Inveresk, that products beyond those which Tullis Russell identified were sold under the Gemini trademark.
The onward sale to the end user.
That's not my understanding of what's being said, but perhaps it's not important.
Well, I'd quite like to understand this. I mean, the way it's defined in the service agreement is simply by reference to coating.
No.
Is that right? That's
No,
as defined in the services agreement in the...
No, we need to look at the definition in the Schedule Part 3 of the acquisition agreement.
Yes.
Well, incorporating the trademarks.
Yes. And we say, Tullis Russell say, products incorporating trademarks are restricted to X. And we say they are not restricted to X because other products were in fact sold under the Gemini trademark.
Although not affixed to it?
What does incorporating mean?
Sorry? That may well be the issue, or one of the issues.
So how's the poor old expert going to resolve all that?
Well,
Because until he's resolved that, he can't decide what the tonnage is.
I may have dug myself a large hole by going here, but all I was seeking to do
probably
was
my fault, I'm
to
sorry.
identify that there was an issue.
Yes.
Establish that. So.
Yes. I mean, I'm not
Some of us over here are quite muddled about it.
I'm not for one moment seeking to advance Inveresk.
Well, we don't... it's not our job to answer,
Indeed.
that point. But... Sorry, please go.
At page 157, Lord Drummond Young says that the Tullis Russell were selling them under certain brand names, which are not scheduled brand names,
Yes.
while they were selling them. But these were brand names of products which you
Yes.
sold as grades of Gemini.
Yes. That's what I meant to say in
Yes.
answering the Lord's question.
Yes.
I may not have.
So they weren't sold as Gemini, in fact, and therefore, literally, they weren't within the meaning of products
Yes.
in part 3 of the schedule.
No doubt that would be the argument against.
Perhaps finally you could just give us the reference to the current state of the pleadings on this issue. I'm not asking you to read it, if you could just...
Current state.
I think you told us that this point had been amended in the light of what Lord Drummond Young said. And was,
One of the laws at page 181, letters B to D.
So that is the latest state of the record, is it?
That's my understanding. This is 181D is the next page.
Yeah, okay.
Particularly between B and D.
Yes. So that
and this is, whose pleading is this?
Tullis Russell's pleadings added by Tullis Russell after the debate before Lord Drummond Young, I believe.
Right.
That's right. Yeah.
Well, where do we go from here?
I'll try and get myself back on track. Yes, if I could invite your lordships to look at paragraph 4.2a, read with 4.4b, of the schedule part 3, which is
Yes.
on page
293.
293. So 4.2a entitles Inveresk within the review period to notify the purchaser in writing of any adjustments they consider need to be made to the draft consideration accounts. And if we follow that through to 4.4b, if the vendor and the purchaser are unable to agree within 5 business days, then paragraph 5 of this part of the schedule shall apply. So what's envisaged is that if Inveresk notify Tullis Russell of any adjustments if, under 44B, the parties are unable to agree on the adjustments to be made to the draft consideration accounts, then paragraph 5 applies, and that entitles Inveresk to notify Tullis Russell that it requires a tonnage audit. And my submission is that what is clearly the intention of the parties is that a tonnage audit occurs where Inveresk maintains a challenge to the draft consideration accounts. So it's for Inveresk to invoke a tonnage audit.
Well, couldn't it be said against that in the circumstances of this case? There were, in fact, two disputes up to the 30th of January. Dispute number one was you saying that the consideration accounts don't give you enough, and Tullis Russell saying they give you too much.
Well, de facto, that might be right, my lord, but in terms of contractual entitlement, the only party entitled to invoke a tonnage audit is Inveresk. And that's really...
It doesn't follow. That doesn't tell you anything about what happens at the audit, though, does it?
Well, I'm getting there.
But what happens, do you say, if you didn't notify the purchaser that you require an audit? I mean, it may be the draftsman thought this was extraordinarily unlikely, and that you would inevitably call for an audit, otherwise there's no way you're going to get paid anything at all.
Yes.
No, you give a 43B notification.
Yes. Then, in my submission, by implication, in the same way as by implication in relation to the period in which it actually happened, the Inveresk are in effect withdrawing their adjustments, and the payment date follows as a result of that.
So you say...
Perhaps before my lord asked me the question, the reason I say that is because, in my submission, a tonnage audit can be invoked only by Inveresk.
Indeed, and there's some sense in that, isn't there, in general terms, because they are looking for payment of the additional consideration. And if there's a disagreement between the parties, the contractor said, well, the way that disagreement will be resolved will be through a tonnage audit. And if your clients didn't call for a tonnage audit at all, they'd never get paid.
The way I would prefer to put it, my lord, is it's not if there's a disagreement, it's if Inveresk maintains its challenge, a tonnage audit will take place.
Are you really saying that 4.3A and A or B applies, even though it's subject to adjustment because they can't quite literally apply?
Yes.
Well, I'd like to be sure, because 4.3A is that you actually take a positive line and say no adjustments are needed.
Yes.
That's your position. And,
Yes.
and you would say, well, it doesn't matter if they're now telling you that they want adjustments, you simply don't want them, and that's it. And then C is where you do not notify of any adjustments, so that it's silence as opposed to a positive statement.
Well, where we are, my lord, is that Lord Savile's postulated that there isn't agreement during the 5 days, and Inveresk doesn't notify the purchaser that it requires a tonnage audit. And my Lord Savile also recognised that was unlikely to be the situation. And I've been asked, how would the contract work in that unlikely event?
Well, surely the draftsman contemplated that it would work by your notifying the purchaser that you don't want a tonnage audit in order to, under 4.3b.
Indeed,
if you failed to do that, I don't know what the result would be, but the draftsman undoubtedly thought that that's what would happen, and that any person in your client's position with any sense would obviously do so, because that would trigger his right to be paid.
Yes, and that's consistent with my submission that the words during the review period are not intended to exclude the Inveresk from taking one of these options after the review period is expired.
Although 4.3a, I think on any view of where the parties got to with the review period, you're way out of time.
Well, the point I've sought to make, Lord,
because
is
you've moved on from 4.2 and 4.3, you've moved into 4.4.
Yes.
4.4.
I recognise that, Lord, and that really was the focus of Lord.
So you're not seeking to say that you're still entitled to notify the purchaser that no adjustment needs to be made under 4.3a.
I am saying that, and that was really
You're saying under 4.3a?
Yes.
Despite the fact it's not within the review period?
Yes, and that was the discussion I had with Lord Collins at the outset of my submissions, which is that the purpose of the words during the review period is not to prevent Inveresk from taking one or other of these steps after the expiry of the review period. The words during the review period are there to preserve a timetable to enable the purchaser, the vendor Inveresk, to secure prompt payment if that's what he wants to do.
But what in fact you did during the review period was not under 4.3, but you acted under 4.2a.
Yes.
So I find it a little bit difficult at the moment that you having acted under 4.2a, you can simultaneously argue, well, okay, I did that, and despite the review period having long expired, I can then act under 4.3a.
Well, it really all depends on how you view the words during the review period.
I'm sorry, it all depends?
It all depends on how you view the words during the review period. Are they, simply as I say, a means of ensuring that if the Inveresk takes a particular route, it gets early payment? Or are they intended to make sure that Inveresk, if it doesn't do 4.3a, b or c during the review period, it can never do it again? And
of course, it might be said against you that you're giving a very broad and generous construction to the time period in 4.3a, which is not quite the construction you're giving to clause 5.
Well, as I say, it turns on, this part of the discussion turns on whether you regard the words during the review period as exhaustive of Inveresk's right to take any of these steps.
Well,
in my submission,
speaking for myself, I do find at the moment great difficulty in you invoking clause 4.3a in view of the fact, firstly, that you had invoked 4.2a, and secondly, because come the 14th of March, the review period was long over.
Lord, I don't think I need to invoke 4.3 at all. The way it was, I'm content with the way in which it was approached by the extra division on this matter. If I could just refer, my Lord, if I can find the reference to page 19 of the volume 2 of the core.
So page 19.
Page 19 of volume 2 of the core volume.
House judgment. The very beginning of
Yes, I haven't got it separate, unfortunately.
it should be page, starts at page 3.
Yes, that's right. Yes, I'm looking at, I'm sorry, which page?
Page 19, my lord. This is the
Yeah, that's
opinion
it.
of,
Thanks very much.
opinion of the court.
Yeah. Whereabouts in this enormous paragraph?
Yes, I'm in the very long paragraph. And the way the extra division put it, about a quarter of the way down the page, there is nothing, we repeat, in the language of the agreement, however, that prevents the respondents withdrawing their proposed adjustments and indicating their agreement with the figure in the draft consideration accounts, thus rendering the auditor's task of verifying and confirming it redundant. And then about 6 or 7 lines further down, accordingly, we agree with counsel for the respondents that the intention of the parties in the situation that has arisen.
I'm sorry, I'm
Yes,
obviously looking at the wrong page.
Sorry, my lord, it's
I'm looking at the report, Appendix Part 1, Volume 1 of 2, page 19.
it's your volume. It's the big fat volume.
I've now given the right page 19.
Sorry, my lord, if I
I'm so
didn't
sorry.
make it clear.
I thought you had the right one.
It's page 19, which is page 679 of the opinion.
Yes.
About a quarter of the way down the page is a sentence 3 or 4 lines from the end. There is nothing, we repeat, in the language of the agreement, however, that prevents the respondents withdrawing their proposed adjustments and indicating their agreement with the figure in the draft consideration accounts, thus rendering the auditor's task of verifying and confirming it redundant. In particular, we do not consider that the provisions regarding payment as set out in paragraph 4.5 of the schedule can be read to have that effect. Now, if I just pass over the next half dozen lines where they're dealing with this payment issue, the court then says, accordingly, we agree with counsel for the respondents that the intention of the parties in the situation that has arisen, although not expressly provided for, falls to be read as being that payment was due when the draft consideration accounts were no longer being challenged on the withdrawal of any proposed adjustments and prior to the completion of any tonnage audit. And that, in my submission, that is the correct approach.
Just to add to that, the way Lord Glennie put it is at page 100 in Appendix Part 1, in his paragraph 23.
Yes.
Do you have that? I mean,
Yes, my lord.
He's saying that, in I think the fourth sentence, if the purchaser cannot revise its draft consideration accounts, which is his basis, it must be open to the vendor to drop its objections and indicate its content to accept the position put forward in the draft consideration accounts. So he's not pinning this down to any particular provision. He's just simply saying that the system works on the basis that while you can propose adjustments, the purchaser cannot do so. And it must follow to make commercial sense of this, that if proposed adjustments are withdrawn, then all you're left with is the draft consideration accounts.
Yes, indeed, Lord.
Does this mean, that, Mr. Carrier, that if you go into the discussions which are envisaged about these accounts, if you put in adjustments, and these are, you get the books out and you look at the figures and so on, and you go through them and see, oh yes, you're right in quite a lot of the bits, but lo and behold, there's a couple of items which we've got wrong. Does that mean that these can't be allowed for?
Well, I
They
think
can't be raised as an issue in the discussion?
what they can't be is the subject of an invocation of the tonnage order procedure by Tullis Russell.
I'm just asking, in these discussions which are envisaged by the contract, of what are, after all, draft accounts.
My answer, my lord, is that the purpose of this discussion is to discuss Inveresk's adjustments.
Not to reach the correct figure.
4.4, if the vendor notifies the purchaser that during the review period that certain adjustments need to be made. So the de quo of this discussion is notification by Inveresk that certain adjustments need to be made. It says nothing about Tullis Russell putting forward any adjustments.
I mean, what we're talking about here is trying to discover what the correct figure, should the parties intend that the correct figure should be for tonnage and the correct figure for additional consideration should be. I mean, that would have thought might be what they would have intended. I can see, of course, if one can agree and so on. That's
No, the way I would put it, my lord, is that the system works by the purchaser, Tullis Russell, preparing draft consideration accounts, which then may be, and putting it very broadly, may be taken by Inveresk to a tonnage audit if it continues to challenge the draft consideration accounts. And there is no room for a tonnage audit at the instigation of Tullis Russell.
If the auditors refuse to undertake the expertise that they were asked to undertake under Clause 5, and you were maintaining that the draft consideration accounts were not accurate, would you be stuck with the consideration accounts, or would it be for the court to decide what the true figure was?
I think the route for Inveresk would be to seek specific implement against Tullis Russell of the obligation to procure and deliver a tonnage audit. I think that's the answer.
Well, that might be an impossibility because it's the purchaser's accountants, and if the purchaser's accountants fail to do it, you can't go off and find some other accountants, can you?
Well, you've reached a frustration point then, haven't you?
Wouldn't you then have to sue more or less generally on the basis that the system for sorting out the additional payment had failed, that you were entitled to an additional payment? You would then have to say, well, the additional payment is in the consideration accounts, and you'd be met by the defence that, yes, we do owe you some more money, but that's not the right figure.
Well, one option would be for Inveresk to do what they've done, which is to withdraw their adjustments and take the money. As far as I can see, there's no requirement that the purchaser's accountants be PwC, and if PwC for some reason don't do what they're supposed to do, then I can't see any reason why.
Well, they should get some other accountants.
Yes.
Yes, I follow that.
Yes.
Just going back to, if I may, to 4.3a, and the difficulty which I expressed I personally found with it, the application for an audit was made pursuant to 4.4b by your clients.
Yes.
Because that's what they say in their letter, calling for an audit.
Yes.
So at that moment, there wasn't an agreement between the vendor and the purchaser. And so at that moment, your only option to try and get your payment was to ask for an audit.
Well, I would say no. I would say that if Inveresk decided that it didn't want to waste any more time for the sake of the difference between the draft consideration accounts and its proposed adjustments, and as a result, Inveresk's challenge fell away, then at that point, just as on the 14th of March in my submission, Inveresk would have been entitled to notify that it no longer had any adjustments to the draft consideration accounts, and the process would result.
How do they get round the 5 business days in 44B? Because once the 5 business days have gone by, then the only mechanism left is the tonnage audit, isn't it?
No, because what 44B envisages is that the vendor Inveresk has to take an additional step to bring about a tonnage audit, and that is notifying the purchaser that it requires one.
Can't you go back to the first line of 4.4? Because
Yes.
the whole of that clause proceeds upon the basis that certain adjustments need to be made. Now, is your position that assuming that within, let's say, a few hours after the 4.4b notification, you change your mind before anything has actually happened, Tullis
Yes.
Russell haven't had a chance to do anything about it, you say, well, we can change our mind, say, well, adjustments no longer need to be made, and therefore we can go back to 4.3.
Yes.
I mean, the machinery could work that way. The complication in this case may be that things have gone too far to stop you doing that, but your position, as I understood it, was that you can go back at various stages and change your mind and
Yes.
go back to the older provisions. And
Yes.
You have to say, though, after the expiry of the review period, that it's implicit in this whole structure
Yes.
that the vendor retains a discretion whether or not to require a tonnage audit. There's no obligation upon him to do so at any rate
And
expressly.
that is
And
the-
if he chooses not to, then the effect of that would be that he abandons his claim for the adjustments. And the answer would be, as contemplated in clause 4.3 generally, that
Yes.
other things being equal, you take the purchaser's original accounts.
Indeed, my lord, and that's the way, as I understand the opinion of the extra division, it approached the matter.
Could you go back after the business audit, tonnage audit had been given by the accountants?
Well,
To say, well, that's all very interesting, but we actually do agree, a bit late in the day, but we now do agree on the consideration account. So we'll pay our share of the accountant's fees, but you can forget the audit. Or is there some moment when it's too late?
Well, I think if you look at 5.4, my lord, within 5 business days of receipt by the vendor of the tonnage audit statement, the vendor and the purchaser shall jointly incorporate in the draft consideration account. So,
So I think you're saying it's too late.
but by that stage,
Yes.
according to the
You'd
express,
have to be able to show manifest error,
perhaps, yes.
Yes.
or
Yes.
whatever the other thing is,
Yeah.
fraud.
Yes.
their decision.
But are you saying you can go back to the consideration accounts at any time before the audit is produced?
Yes. I think it's interesting, now that I look at it, that the only provision which obliges the parties to well, perhaps not the only provision if I look back at 4.4a, but 4.4a and 5.4 are provisions, I think the only ones, which require parties to finalise the draft consideration accounts.
Sorry, which is
I think 4.4a,
yes.
which provides that if the purchaser and the vendor agree, then they shall jointly incorporate the adjustments into the draft consideration accounts, and the so on shall be the consideration accounts and the tonnage for all purposes of the agreement. And there's also provision in 5.4 which obliges the parties to, in effect, finalise the consideration accounts, but these are the only two provisions.
Yes, I think, do you accept that there has never been an agreement in writing under 4.4a?
Yes. So, Lords, and really answering Lord Hope's question, my position is that the whole process is driven after delivery of the draft consideration accounts by a challenge by Inveresk to the draft consideration accounts.
Your difficulty, to my mind, is what it is that the contract provides that the experts should do, and that the expert must carry out a tonnage audit, which is defined as the external verification of the tonnage. No reference to draft accounts or anything.
Yes, no, my Lord, I
mean, that's the difficulty.
in my submission, it isn't a difficulty, because the issue is not what does the tonnage audit produce, but what gives rise to it. What is it that takes one to a tonnage audit?
Yes, but assuming all that in your favour.
Yes.
When the audit gets there, it's independently defined in.
Well, he just gives a figure.
Yeah,
for the
but when
tonnage.
he's done that.
I think that's all he does.
You're accepting Lord Glennie was wrong, are you?
Well, it's not a necessary part of my argument, if I can put it that way. I mean, if one traced the history of this litigation, the position adopted by Inveresk in response to the attack from Tullis Russell has had to meet that attack. And if we look at, for example, the position, the Tullis Russell adopted a certain position before Lord Glennie, withdrew it, before Lord Drummond Young, who first considered the matter, and went to the inner house and was remitted back to a different Lord, ordinary Lord Glennie. Tullis Russell adopted a different position before Lord Glennie, changed that position yet again when went before the extra division. And my position is that it is absolutely not necessary for the respondents in this appeal to take the position that the accountant does any more than simply produce a tonnage figure.
But then doesn't clause 5.4 says that that tonnage figure is then the figure which goes into the accounts?
Yes.
Now you might say, I can see you might say, well, if you look at clause 5.4 and the reference there to draft consideration accounts, that shows that actually the whole basis of this whole debate, including the tonnage audit, was focused on the draft consideration accounts. But it nowhere actually says that in quite that way. It simply means that that will be the figure incorporated in the draft consideration accounts in substitution of whatever was previously in it. And since we know that what the expert was to do was to make an external verification of the tonnage,
Yes.
it was the duty of the expert to look at all the materials, decide what the tonnage is, put it in the draft consideration accounts, and then they become the consideration accounts and the amount payable.
Yes,
And that's the,
I understand
that's the
that,
case on
Lord.
the other side, really.
Indeed, and what's being said against me is that I think, if I'm not doing it an injustice, is that once you get to the expert, it's possible that he might produce a totally different figure from that desiderated by
Because he has
Inveresk.
to do what an expert does.
Yes,
when
and I don't have any difficulty with that. And my point simply is, that isn't the point. The point is, what is it that takes you to a tonnage audit, not what it might produce. And what takes you to a tonnage audit is it being invoked by Inveresk.
Yeah, but once you've done that, you're stuck with the terms of the contract.
No.
Well, you're saying, I mean, to take it at its very simplest from your point of view, you can invoke it today, but this evening you can change your mind before anything has happened.
Yes.
Now, for myself, I wouldn't have thought there was any great difficulty about that, so long as nothing has actually happened.
Yes.
And if you do that, you go back to the first line of 4.4 and you're saying, well, actually, our position now is that adjustments do not need to be made.
Yes.
I follow that, but I'd been supposing in my question that the tonnage audit actually takes place. I quite agree that there's a whole further debate about waiver and the like.
I mean, there is this problem about timing and just how far things have actually got.
Well, that's the point that I made at the outset of my submissions, is that whatever Tullis Russell did, they did not procure and deliver a tonnage audit, and the accountants did not start work on a tonnage audit because the whole thing got held up on a failure by the parties to agree PwC's terms and conditions of employment.
And you're saying it wasn't any part of, you didn't have to do anything. It was all, it was entirely for Tullis Russell to make clause 5.5 work. And because they failed to do it within the timetable, it's open ground for you now to say, well, we're withdrawing from that arrangement.
Does that mean in turn that you were wrong in complaining about the terms of reference?
Well, I think I'd put it this way, that with the benefit of hindsight, somebody who wasn't involved can see that, as my Lord Hooper said, it was, in terms of paragraph 5.1 of the schedule, for Tullis Russell to procure and deliver a tonnage audit.
I mean, if one looks at the letter of, in Appendix Part 2, the letter of the 8th of February, which your solicitors wrote to Daston Wilson, you say, our clients are disappointed not to have received a copy of the letter of instruction. And the scope of the PwC's engagement is fundamental to the verification of the tonnage, and it should not proceed until the scope of PwC's constructions and the list of documents provided by has been agreed. So you were telling them, you can't go on with this.
That's what they said, my Lord.
Sort of counter-waiver point.
Well, my point is that let's just cut through all this argument and counter-argument and look at what the contract says. And the contract says it is for Tullis Russell to procure and deliver a tonnage audit.
But you were stopping them from doing
We weren't stopping them. We were not stopping them.
You're saying don't do it.
Properly advised in my submission, Tullis Russell should have procured and delivered a tonnage audit if that's what they wanted to do.
Well, they should have found some accountants who were willing to... they should have either agreed to the accountants' terms and conditions or found some other...
It was you who wanted it, and you were saying not yet.
Well, it wasn't just us, my Lord, because if you look at the draft letter, which is appended to number 1, but yes, and that's why I sought at the outset, very advisedly, to state the position as neutrally as I could, which was that there was a dispute about what should go before the expert and also what his terms of reference were. And I don't seek to run away from that.
It was just that, I mean, you did say, well, they hadn't actually done this in that time and so on. All I'm saying is, you weren't certainly egging them on, to put it mildly.
So you might have waited for 14 days.
Well, I would dispute that, because we were expressly asked about the 14 days and refused to extend it. But, Lord, I come back to the point that the obligation under para 5.1 is quite clear. It's to procure and deliver. It doesn't say anything about initiate a process of submission and counter-submission at all. And I'm not seeking to, wherever the responsibility lies, I am not seeking to blame, in any moral sense, Tullis Russell for not doing it. I'm simply pointing out that they didn't comply with their obligation. And if it's suggested that it was all our fault, then all I would say is look at the draft letter appended to tab 1 of part 2 of the appendix, where Mr. Gary Wallace of Tullis Russell sought to justify what he called the revised tonnage, which was the figure they started advancing around about the 30th of January.
Just so I understand, it's no particular point, but if one looks at 3.1, do I understand that these consideration accounts could simply be a figure plus, for tonnage, plus a multiplication producing an additional consideration? It didn't
Yes.
actually have to be anything more than that.
Yes.
But it was critical to identify the product to go into the calculation of the tonnage. Is that not right? I mean, is that not really the nature of the dispute, which we see at page 2 of part 2 of the appendix, that they were saying to the
Yes.
saying to the PricewaterhouseCoopers, well, there are items here which shouldn't be included in the products as defined.
In fact,
And you were concerned that if that's what the PricewaterhouseCoopers were going to operate on, you would end up with a figure that was binding on you, which omitted product which you said should be included.
in fact, although I don't accept it's relevant to the construction of these provisions, de facto, each party had a different view about what the product was, and apparently still does.
Yes. Well, where do we stand then? I mean, you're obviously, your primary position is, as you've explained, but is there any fallback position? You're stuck with your averments, which depend upon your interpretation of the schedule. But on any view, even Tullis Russell concede you're entitled to some sort of payment, and the question would be, on what basis can you obtain it? Because the agreement has broken down. If you're wrong.
Well, I think perhaps my Lord could just give me a minute. In any case, I've got was the one we made. Lord, my position is that the agreement hasn't broken down, and I adopt the reasoning of the extra division, which is that what I offer your lordships as a construction of the contract is, although not the subject of an express provision, it is one that's implicit. And in a sense, the issues have been canvassed.
So, but I didn't quite follow that. How do you arrive at your results? You say that you could waive.
No,
You don't say it doesn't depend upon a waiver.
I don't depend on waiver,
No.
but
Let's leave waiver on one side.
Yes.
Then. How does your analysis work if it isn't a waiver case?
because we are implicitly entitled to withdraw our adjustments and to withdraw our election for a tonnage audit.
Yeah, originally, you put it on the basis, and I think you still do,
Yes.
of a combination of 4.3a and 4.5a,
Yes.
although not read absolutely literally.
Yes. Indeed, Lord.
I understand
Although
that.
you didn't ask for an audit under 4.2b, you asked for an audit under 4.4b.
Yes.
And I quite understand your point that it's implicit that you could have said I don't want an audit, not activated clause 5.1. I understand that, but you did activate clause
Yes.
5.1.
And the whole thrust
Now then what?
Well, the whole thrust of my argument is that a tonnage audit is only envisaged in a situation where Inveresk continues to challenge the draft consideration accounts. And although it's not expressly spelled out, it's not excluded by clause 4.3 that as and when Inveresk decides that it does not challenge the draft consideration accounts, it's entitled to withdraw its adjustments and withdraw its election for a tonnage audit.
And would that be so even if an audit had been carried out? I mean, suppose within the 14 days, the auditors have produced an audit.
I think that what I would accept, my Lord, is that,
You'll be stuck with clause 5.4.
is that once the cut-off point would be that, in terms of clause 5.4, would be the receipt by the vendor of the tonnage audit statement.
But that you have to involve implying a term, does it? That, because there's no express term that says that you can withdraw halfway through the accountant's work, especially in circumstances where clause 5.2 says that it's up to the experts to decide who's to pay for
I don't
this.
need to go that far, but it does seem to me that the contract does provide a point at which the tonnage audit statement must be incorporated into the draft consideration accounts.
5.2 tells you that their decision, if they get to the point of a decision, that's final and binding and not open to review subject to question on any ground whatever.
Yes, I'm obliged.
So once they reach the decision point,
Yes.
at least, it's absolutely...
And it must be final and binding on the question they were considering, namely, what was the tonnage?
Yes.
That must be the point that it's final and binding
Yes.
about. So you'd have to concede on that basis that if they got that far, you'd be stuck with that figure
Yes.
for all purposes under clause 5.4.
Yes.
Do you accept that if the audit had gone ahead and the purchaser's accountants had understood product in the way in which Tullis Russell were saying, not at first, I agree, but in the end, were saying was the way it should be read, you would be stuck with it?
You mean if a tonnage audit became binding
Yes,
in terms of the machinery of the contract?
yes.
Well, I think I'd need to think about the bases upon which an expert determination could be.
Well, perhaps I didn't put myself clearly. It goes to the audit. The accountants then look at it, and they look at the agreement, and they come to the conclusion that products means products as contended for by Tullis Russell, and therefore produce the figure for which Tullis Russell are arguing is in fact the correct figure. Would you be bound by it?
Well, in terms of paragraph 5.2 of the contractual machinery, it is stated to be final and binding on all respects on the parties.
If they misdirected themselves on a matter of construction of the agreement?
Well, that might be an option to seek to review it on that basis.
And if you accept that, doesn't it follow that the auditors, the accountants, are not in any way bound by the draft consideration accounts?
I think I've already accepted, my lord, that it doesn't do any harm to my argument, and I can live with the view that the auditor just does an audit.
But then isn't the machinery apt to deal with the situation that arose as of the 30th of January, namely a situation in which you're claiming that the amount should be greater, and Tullis Russell are claiming that the amount should be less?
Well, I would respectfully say it's not apt to deal with that because the whole machinery of the contract provides that the tonnage audit is invoked by, and I'm stating the position quite generally, is invoked by the vendor, Inveresk.
Well, the fact that it's invoked by the vendor, I think it's probably my fault, I'm not actually following that. The vendor invokes it. Let us say in the hope that the accountants will come up with the figure that they're contending for.
Well, I think the simplest way I can put it, rightly or wrongly, and I think the case does hinge on this and other related issues, is that in my submission, the rationale for a tonnage audit disappears as and when the vendor Inveresk no longer maintains a challenge to the draft consideration accounts. Now, if I'm right about that,
I follow that submission.
And if I'm wrong about it, I think I lose.
Sorry, I interrupted you. The difficulty I'm presently finding is, yes, that's perfectly true, and that would work perfectly well in a case where the Tullis Russell were maintaining that the consideration counts for the best thing since sliced bread, but they're not, and they weren't.
And my submission to that, politely, is so what? Because the machinery is not intended, set up or geared towards, or for the purpose of resolving an adjustment that Tullis Russell wishes to make to its own draft consideration accounts.
Yeah, well, that at the moment seems to me a little inconsistent with the concession that if the audit had gone ahead, the auditors could completely ignore the draft consideration accounts because the only thing they're looking at is the tonnage.
The way I sought to answer that, my lord, is to say that the issue is not what the tonnage audit produces, it's what triggers it.
Could I take you then? I mean, you've said if you're wrong on your rationale, which is that it all depends on whether or not you're insisting on your adjustments. Now, the Dean of Faculty's position ultimately, as I understood it, was, well, until a figure has been arrived at by means of a tonnage audit, you're not entitled to payment. But the timetable set out in Clause 5 has long since disappeared,
Yes.
and it seems to be a complete impasse now between the parties as to how that clause can be made to work. What happens? I mean, you're on the pleadings, you've no solution to it. Do you just accept that if you're wrong, we would have no alternative but to dismiss the action?
If
you're wrong on the basic proposition.
My submission is that ultimately should be a matter for the commercial judge, because he will regulate procedure in this case. It will be remitted back to him, and he will hold a hearing at which parties will be given an opportunity to discuss further procedure, and that would give the pursuers in this action, Inveresk, if so advised, the opportunity to amend.
So you don't accept that if you're wrong, then the court would have to conduct an exercise of calculation of the additional consideration, if any?
Well, I think that if we are wrong, the action I mean, the issue is complicated by the fact that and I think the reason why I would submit that the correct course is not to dismiss the action is that the Inveresk have an alternative position, which is that if a tonnage audit is triggered, a declarator should be pronounced to the effect that the product means X.
So you would still want to maintain your second conclusion, is that?
Well, I think we'd at least want the option of...
I thought that had been referred to some mysterious...
mutual,
some
kind of...
You know, some House said that had gone away.
I'm sorry, I'd forgotten that because I...
So that's still up in the air. It's something that's to be resolved. But the problem you have is, strictly speaking, on your pleadings, the only basis for payment is on the assumption that you're right in your underlying proposition, your underlying rationale, as you put it. Well, and if you're wrong about that, there doesn't seem to be anything left to entitle you to payment of anything.
There's a certain flexibility in the commercial procedure in the Court of Session, and had this case, let's say the case had been decided against Inveresk by Lord Drummond Young and had never been reclaimed, then I think what he certainly would have been invited to do and might have been disposed to do was, after having decided that matter, put the matter out by order to see whether the correct course is just to dismiss the action or to allow the pursuers the opportunity to amend.
Which might lead to what Lord Collins was suggesting, that you might be driven to the position that it would really ultimately be for the court to arrive at something on the basis that the system laid down in the contract had been frustrated by the events.
Yes.
And you're driven back to some situation which is independent of the contract, but nevertheless gives you a result.
Yes.
What would these environments be that you would be adding, Mr. Carey? I'm completely lost as to what...
Well, I may have lost myself, my lord.
The first plea in law says your pleadings are irrelevant, lacking, and so on, and it says it should be dismissed now.
Yes.
I mean, that's...
Well,
if that were... I mean, your position, your pleading case is pleaded on a particular basis, and so on.
Yes.
But how does the mediation, the point about the supply, the product, how does that fit into all this? I mean, when the thing was before Lord Drummond Young, he would have decided that point in your favour. Now, that's input into any kind of analysis of the tonnage.
Yes.
Isn't it? Logic might suggest that should take place before the expert has a go at it, because otherwise how is the expert to know what the material he's to use in his calculation of the tonnage? Now,
Well,
so
I wonder-
one would expect,
yes.
therefore, this mediation to take place now, and the next stage, one might have thought, if you're wrong, would be either that the court will have to decide what
Yes.
the rights and wrongs is, or maybe you could have go back to the contract without the 14 days and have an expert
Lord, rather than
determination.
taking
One
up
or
your
other of
lordship's
those
time, I wonder if I
But
might...
your clients can't be deprived of any right.
I wonder if I might discuss with Mr. Lake, who's had the good fortune to have been in this litigation from the outset.
I think
the Dean of
it's
Faculty
fair enough.
myself.
I think if I'm not, I hope putting words unfairly into the Dean of Faculty's mouth, but I think it's accepted by Tullis Russell that you are entitled to something. There's obviously a dispute as to what that amount is.
Yes.
And at various points he was suggesting that it might go back to the outer house and so on, and it may be he would accept that the proper course for us to reach if we were in his favour is to make our position clear in the judgment and send it back so that the question of adjustment could be addressed in a more appropriate forum than the Supreme Court.
Lord, I think the only... if I could have the opportunity of discussing that
Yes.
with Mr. Lake and my instructing
Yes, well, we've
solicitors.
nearly reached the short
I
adjournment.
think the only other matter I had to deal with on this part of the case was the issue of payment date.
Yes.
And I think the position has been adopted by all of the courts below that by implication from clause 4.5 and 4.3, payment date would be the 14th of March when Inveresk notified Tullis Russell that no adjustments need be made to the draft consideration accounts.
Yes. Well, I wonder whether that would be, I'm sure it is a convenient point from your point of view, but if we adjourn now until 2 o'clock, and you can bring us up to date as to what the procedural position is, and then we can go on to the second question.
Yes.
2 o'clock.